Next. Although in the officer's mind he wasn't arresting her, he did use the force of his position to direct her to do what he wanted her to do. So the plaintiff went out of fear of consequences, should she refuse. So the plaintiff was imprisoned, and for her personal inconvenience and the upset arising from the incidents, she was awarded damages of $500. So another false arrest case, Nolan versus Toronto Metropolitan Police, 1996. The facts are, 2 police officers went to an apartment building due to a disturbance. Nolan lived in the apartment building, but not the apartment where the disturbance was, and was questioned by police. Police asked for his ID. When they left, they checked the name and found that there was a warrant out for a person, out for the arrest of the warrant, sorry. There was a warrant out for the arrest of the person by the same name with the same birthday. But there were some significant differences between the two. One had a permanent address in Toronto, and the other didn't. One was a native, and the other was not. But nevertheless, they went back and arrested him and took him to jail, and in the process, belittled him and used racist insults. So the analysis regarding false imprisonment, or the tort of false imprisonment, was that Detective Cartwright failed to exercise his statutory duty and was negligent in not respecting the endorsement of the warrant. The endorsement gave Detective Cartwright the authority to question and investigate the decision of Detective Bratt, but he did not do so. So the decision to use the warrant to imprison the wrong person. The jailer, so the person at the police station or the jail where they went to, owes a duty of care to the prisoner, as per Parker versus Attorney General. And sections 498 and 499 of the Criminal Code set out the obligations of the officer in charge. In assessing the reasonableness of the detention, the court has considered those provisions in their entirety and has come to the conclusion that the tort of wrongful detention has been proven. There's also the tort of intentional infliction of mental distress. So what they had to say about that was that while the plaintiff was being photographed and fingerprinted, there were rude racist comments from at least one officer. The plaintiff's evidence is, I think they were being a little bit rude. So they mentioned some racial remarks about him being a Mohawk. They said, we're going to fix you, you Mohawk. After that, the plaintiff began to drink, became so depressed he stayed in his room and wouldn't go out. He avoided class and wouldn't talk to his teacher, and he was also stated as saying that he didn't want to make it a Native issue. And why do you want to bring the Native issue? What do you want to bring the Native issue in for? Which is exactly what they did. So the effects of the whole evening on the plaintiff were serious. The court concludes that the kind and seriousness of the harm contemplated by this tort were actually suffered by the plaintiff. The court has come to the conclusion that these comments were so outrageous in all the circumstances as to attract liability for the intentional infliction of mental distress. And the decision in damages, $2,500 for wrongful conviction. And Cartwright and Bratt, I believe, were to split this. There was also $6,000, and I don't know if it was split between them or they each had given $6,000, but Officer Bratt and the Metropolitan Toronto Police Service Board. And that was for general and punitive damages associated with the wrongful detention and the wrongful infliction of mental distress, and $380 in costs. So we see 2 examples of false arrest where the tort was applied and the plaintiff was successful. If we look back at the false imprisonment case, we looked at Bird versus Jones, we see that the tort was not successful, and in that case they made the distinction between partial and complete imprisonment. So, why else might you not succeed in an action brought for false imprisonment? Consensual restraint. And I believe this was one of the cases in the notes after Byrd and Jones. We also saw an instance of consensual restraint. So in Bale and New Ferry versus Robertson in 1906, the plaintiff consented to the terms of going onto the ferry, or paying the penny to go through the turnstile. So the case here is Hurd versus Weardale Steel, Coal and Coke Company in 1915. And the appellant, Hurd, was employed at the colliery, or the coal mine, and it was owned by the respondent. So Hurd was in the mine and was prevented from using the cage to exit the mine, and that was the only way to get out. So he was in prison until 1:30, which was approximately 20 minutes, and he wanted to get out because he was refusing to do work that he thought was too dangerous, but that he was ordered to do. And the employer argued that he was guilty of breach of contract, but that's a separate issue. So on the analysis by Viscount Haldane, no person can be restrained of their liberty without authority in law. However, this is in relation to other propositions which are equally important. For example, contract between the employer and the employee. So, he cited the principle of volenti non fit injuria, which means to a willing person, injury is not done. So what conditions did the plaintiff accept when he went down the mine? According to the contract, they were brought up at the end of their shift. Now, the plaintiff refused to do dangerous work and was forced to wait 20 minutes until the end of the shift. And the judge mentions that he's certain that, or quite certain anyway, that the reason he had to wait was because he was being punished for not doing the work. However, it is further noted that the plaintiff had no statutory right nor contract right which entitled him to be brought up at his convenience. The employer didn't refuse to bring him up at the ordinary time, and thus there was no false imprisonment. So here Hurd consented to being restrained in some way. So the principles governing false arrest, there's a few of them. It's unlawful and total restraint of another person, whereby any means of escape is inconvenient or perhaps harmful. And that is, of course, a very gray line. It can be a physical barrier or physical restraint. It can be an implicit or explicit threat of violence. It can be an implicit or explicit assertion of legal authority, which is false arrest. It does not have to be a long time. It does not have to harm the person, and you don't have to touch the person. There are, however, situations where you can consent to imprisonment, such as the ferry or the mine or getting on a train. Also, a third party can be liable if they order a false imprisonment. So if you're a manager, you say to your security guard, stop that person, you can also be held liable. If you are not liable if the arrest leads to a charge. So if you falsely imprison someone, but that imprisonment leads to a charge, I suppose it would be a false arrest in that case, then you will not be held liable. And also, charter rights play a big role in increasing the actions brought against people who engage in false arrest. So, that is Torts Week 5.